hear it.
Let's go. All right.
SJC-11283 Clagon, Commonwealth versus Clagon.
All right, let's proceed. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. We're asking this Court to reverse the motion judge's order that allowed the defendant's motions to suppress. Here, there was probable cause for the search warrant for 8 Blandvin Road based on 3 controlled buys. Here we have 1 buy where the defendant was seen, or the target here was seen leaving. Two where he was seen leaving the apartment, and the first where he's seen returning to the apartment.
What did the judge base the decision to allow the motion to suppress on?
Unfortunately, the motion to suppress was decided in December of 2010, and so the judge's decision didn't have the benefit of this Court's analysis in either Escalera or Tapia. So the Court's decision was based on Commonwealth versus Pena. The appeals court heard the case, I believe it was about a year ago, and then decided the case last summer, June of 2012, and again did not have the benefit of this Court's analysis in Escalera.
But even without those, I mean, what you have here, and I think you're really hanging your hat on, is 3 controlled buys. But controlled buys in what context of information? There was a CI.
Correct.
But is this correct? The CI isn't saying, this is someone who's dealing out of his house. I've purchased out of his house. This is just the CI saying, what does the affidavit say the CI tells officers?
Both that he has bought heroin from the target.
He's bought heroin at an undisclosed location.
And that he knows that the CI sells in the Forest Hill area. And that's where you get from the first buy to the residence. The location, whose residence it is, was an issue in the appeals court. But here you get from the controlled buy where the CI is observed, engaging in the buy, and then watching the target go back to 8 Blandvin Road. I think that's where the address comes onto the radar the first time, is after the first...
Which is in Forest Hills? I mean, in the Forest Hills area?
It's unclear from the affidavit where the controlled buy takes place. But then the 8 Blandvin Road is in the JP area of the city, I believe.
Well, Forest Hills.
Is that Forest Hills?
Yeah, Forest Hills part
Area.
of JP.
I think area, yes.
And then you had 2 more controlled buys where he left the apartment and was observed going directly to the buy?
Directly to the buy, shortly after the phone call was made arranging the buy. And those were controlled on both, on the ends of the informant and then the surveillance on the target, on the defendant.
So it's really those 2 buys that's the heart of your argument with regard to nexus to the home, that he left his home, went straight to the buy.
Correct. As this court said in Escalera and Tapia, that location where the defendant is seen immediately prior to the controlled buys is what's important. And in addition, this warrant sets out the officer's training and experience about a narcotics delivery service. And here, whether the target is coming from his residence or a residence is a distinction without a difference. It's irrelevant. And here, it's the narcotics storage location. The appeals court took issue with the fact that there wasn't any information in this warrant setting out whose residence it was. My argument is here it doesn't matter. This is where the target came from. It's the place immediately prior to.
And there was only 1 time when he was seen leaving and going directly to, right?
Twice. 2 controlled buys, the second and the third, he's seen leaving and going directly to the location engaging in the controlled buy of heroin. I'd also add that the warrant...
How far apart were those?
I believe it goes from the 30 days to a 10 days and a 3-day. The last buy is certainly 3 days within the warrant.
It says during the last 3 weeks is the second one.
3 weeks.
And was there surveillance giving any indication as to what the defendant was doing before they observed him leaving that place, whoever place it was?
No. And additionally...
So the connector that this is where he stored it comes from expert testimony from police officers saying this must be where he stored it, even though he could have come from someplace else and before he left that place. We don't know where he was the minute before he was there, right?
we know he was at 8 Blandvin Road when he took the call to deliver packaged heroin, and that twice, on 2 occasions, he left from that location. Where he was an hour before that, no, we don't know. We also don't know from this warrant whether the defendant walked or was in a car.
Right.
I don't think that matters either, since the cases here, there's no distinction between those that are walking and those that have vehicles. There's still a nexus to search the location where the defendant, where the target was immediately prior to.
The other case, is just the fact of seeing someone, not knowing what they were doing before, not knowing if they lived there, but from leaving a location to make a buy, is that always bare of any other indicia of enterprise? I think that this might be the only case where those 2 occurrences, absent other indicia of enterprise, CI having made a purchase, or saying that he made purchases from the home, or other traffic, foot traffic going to the home.
Yes, I think that's true. The converse is also true, and the cases are very clear that just because it is your residence doesn't mean that there's probable cause to search it. I think it's the Oliveris case where the defendant,
Just the opposite.
correct, dealing drugs out of his workplace. There would not be any nexus to search a residence. Here, whatever this is, a residence, an apartment, whoever it is, it's the location where the defendant is conducting his drug enterprise from. It's where he is leaving immediately prior to with a packaged quantity of heroin here.
Was there sold?
The quantities are not in the affidavit, but it is clear that it is packaged.
Packaged, as in could be a single twisty sold.
But certainly something that requires packaging and something that this court has said is more likely to have been done in a residence than in another place.
In that residence?
Arguably, yes, based on these 2 controlled buys directly from that place. And whether it's packaged there, it's stored there, such that it's accessible to this target, to this defendant, before he goes to the location.
And not in a vehicle, if there was one?
If the officers wanted to search the vehicle, they would need to have put more in this affidavit. They would have
Don't
needed
know
to
if there was
include
one, is
a
the point.
vehicle. Correct.
We don't know how he left or got there or where he went.
Correct. And if it was a vehicle, certainly it would needed to have been included if it was to be searched. This court has no further questions. I'd be happy to rest on my brief.
Thank you, counsel.
Thank you.
May it please the court, I'm John Fennell, and I represent Reginald Clagon. I want to correct something when the Commonwealth was arguing. There's nothing in the affidavit stating that the police knew that Gerald was in the house when the call was received. It just says that sometime after, this is in the record appendix on page 27 and 28 of the Commonwealth's brief. It just says a short time later, and this is after the confidential informant is searched to see whether he has anything on his person. A short time later, Gerard is seen leaving 8 Blandvin Road. There's nothing in the affidavit about staking out Blandvin Road, seeing Gerald go in, and then the phone call's made, and then he leaves. So they don't know that he was in there when the call was received. In any case, the distinction between whether this is Gerald's residence or a residence makes a big difference in this case, because the basis for linking the illegal activity, the drug dealing, with the place to be searched is the police affidavit, which lists their training and experience, which says that drug dealers try to deal away from their house with this sort of drug delivery system, away from their residence, to protect their residents from the illegal activity and shield that from the police. There are other cases where affidavits have discussed a stash house. And in that case, the police in those kinds of cases, the police enumerate how their training and experience in dealing with stash houses works with a drug delivery system. There's a case in my brief, Commonwealth versus Watson, that talks about all the kinds of information that was listed in the affidavit, linking up the police training and experience with a drug delivery system using a stash house as opposed to a residence.
But it does say that his father had a key and had been parking in front of the residence and using it for the last 2 weeks.
Was seen there once, entering the residence empty-handed and using a key, suggesting that the father had more control over this residence than the son. The son was never seen entering the residence with a key in the affidavit. There's no discussion of a key. In all the cases the Commonwealth cites in its brief, the linking between the illegal activity and the residence is predicated on the residence being the defendant's residence. Here, there's no information that it's Gerald's residence. There's no information about drugs stored at the residence in the past, like in many
There's
other
nothing that links him to that residence. No mail, no independent indices of his connection to the.
Exactly right, Your Honor. In some cases, they talk about how they've done RMV record searches or Board of Probation record sources, and from that they get an address to link the defendant with the place to be searched. Here they talked about doing a Board of Probation record search, but then don't talk about what address comes up from that. At no point do they discuss a search that they've done for Gerald linking him to the residence. The only links of Gerald to the residence are the 3 controlled buys within 30 days. So one about 30 days before the execution of the search warrant, returning from the buy to 8 Blandvin Road. We don't know how long it took. We don't know how he traveled and what kind of vehicle. Then about 3 weeks before the search, we have him leaving from 8 Blandvin Road to the deal. We don't know how he traveled, how long it took. And then the third one is 3 days before the execution of the search warrant.
And if he goes directly, why does it matter how long it took?
If he goes directly, if he's driving slowly and maybe searching around in his car, that would indicate that that's where the drugs would be. Or if he's walking, then maybe the drugs aren't. In the Young case, they discussed how walking would make it so that it's difficult to infer where else the defendant could be keeping the drugs but the residence. But the point is, without knowing how he's traveling, we're just left to speculate.
But does the warrant say, or the application for the warrant say that he was in view of the police from the time he left point A until he arrived at this particular house?
I would have to look at the affidavit. It's in the record appendix on page 27, and the sentence reads, a short time later, officers observed Anthony Gerald exiting 8 Blandvin Road and going directly to the predetermined meeting place without stopping anywhere before meeting Z. That's what we know about the trips there. Both trips from 8 Blandvin Road to the location of the buy are described the same way. There is also no evidence here from the confidential informant of Gerald dealing out of the residence or having drugs at the residence on hand for more buys. The evidence here is simply insufficient for a nexus. There's a gap between the illegal activity and the residence that was searched. And for this reason, we would argue that the motion judge's decision should be affirmed. And unless there are any more questions, I'll stand on my brief.
Thank you, counsel.